Three minority MPs have filed an application at the Supreme Court seeking an interlocutory injunction to stop the May 1 implementation of the electronic transactions levy. That's the e-levy. Hon Ablakwa is member of parliament for the North Tongue constituency. Is one of three NDC MPs seeking this interlocutory injunction at the Supreme Court. He joins me on the telephone. Mr. Ablakwa, good evening to you. Hello, Mr. Ablakwa, good evening. Can you hear me? Hello, Mr. Ablakwa, good evening.
Yeah, hello.
Wait, Mr. Ablakwa, can you hear me?
Hello, can you hear me?
I can hear you clearly. I can hear you clearly.
Yeah, I can hear you now.
Fantastic. First of all, this interlocutory injunction application is to be heard on May 4 at the Supreme Court. The Finance Minister has indicated the e-levy application will begin on May 1. How much of a difference will this interlocutory injunction make?
Yeah, good evening, Alfred. Good evening to all your distinguished viewers. I can confirm to you that on our instructions, our lawyers have today successfully filed an application for an injunction at the Supreme Court, seeking to inject the government and its agents and assigns, particularly the Ghana Revenue Authority, from going ahead with the implementation of the unconstitutional and obnoxious e-levy on the 1st of May. You are right that the date for hearing has been fixed for the 4th of May. Our understanding from our lawyers is that once we have successfully filed and all parties have been served, it serves as a stay. And so we do not expect government to go ahead and implement the e-levy on the 1st of May, because that will amount to contempt of the Supreme Court. So we are clear in our minds that what we have done today scuttles the plans by government to proceed to implement this unconstitutional e-levy. Remember that our substantive case, which we filed on the 30th of March, is still pending. We take the view that 136 members of parliament cannot purport to have taken a decision leading to the passage of the obnoxious e-levy. In the Justice Abdullahi case, the Supreme Court held very clearly, without any ambiguity, that when 137 NDC MPs purported to have rejected the budget on the 26th of November 2021, it was an unconstitutionality because we didn't meet the minimum threshold of 138 MPs required under Article 1041 of the 1992 Constitution. So on that same basis, on those same grounds, an inferior number of 136 cannot claim to have passed this repugnant, regressive, and totally punitive and obnoxious e-levy. So we are clear that we have successfully scuttled, for now, the government's plans to implement the e-levy on the 1st of May.
I see.
Government, the GRA, they will have to hold on till the hearing of this application for an injunction on the 4th of May.
So let me establish this. Even though the hearing of this interlocutory injunction is on the 4th of May, the May 1 implementation date cannot take place until this case is heard.
Absolutely. Government cannot go ahead with implementation because they have been served. This has been duly filed, and they cannot. They will be in clear contempt of the Supreme Court. They cannot go ahead.
I see. And there's evidence of service on the Attorney General and all the respondents to this particular suit?
Absolutely. There is no doubt. There is no ambiguity about that.
Hon Ablakwa, I thank you for your time this evening.
You're welcome.
He is a member of parliament for the North Tongue constituency, one of three members of parliament seeking interlocutory injunction on the implementation of the e-levy beginning May 1. He says, Portia, May 4, it will still prevent the government from